My dear friends, I am taking next question of paper second. What is the question? What are various processes which a criminal courts issue for compelling a person to appear before a court? Answer. According to the provisions of CRPC, there are 6 kinds of process to compel the appearance of a person in the court. First type, summons. According to section 61, every summons issued by a court shall be in duplicate, signed by the presiding officer of such court or by such other officer as the High Court may direct from time to time under this court, and shall bear the seal of the court. Another point, summon. Summon is a milder form of the process issued for enforcing the appearance of the accused or for the production of the documents or thing. It should be clear and specified and bear the seal of the court and also the name and address of the persons summoned and also the place and time, date and time when when the person appear before the court. My dear friends, these are the conditions of the summons. What type of summon is and what is the matter of the summon? Everything has been described in this paragraph. Now I am taking more about summon. My dear friends, summons. It should also contain the place, time, and the nature of the offense committed. This is also a point of the summon. Summons how served. You see here how the summons are served. According to section 62(1), every summons shall be served by a public officer, by a police officer, or by an officer of the court, or by the public servant under the rules. My dear friends, every summons shall be served by a police officer first, and by an officer of the court second, and by the public servant, this may be the third, under the rules or under the rules of the state government. The summons shall be served personally on the person summoned. Every person on whom a summons is served shall sign on back side of the duplicate copy as a receipt, and the duplicate copy is to be submitted to the court by that officer for the proof. Second point, my dear friend, this is the first point, summons. How summons are served? This is the first point. Second, warrant of arrest. After summon, second point is warrant of arrest. According to section 71, every warrant of arrest issued by a court under this code shall be in writing, signed by the presiding officer of such court, and shall bear the seal of the court. This is the language of the warrant issued by the court. And the more about the warrant is, my dear friends, Every such warrant shall remain in force until it is cancelled by the court which issued it or until it is executed. This is the condition of the warrant. And next, power to direct security to be taken. According to section 71, any court issuing a warrant for the arrest of any person may in its discretion direct by endorsement on the warrant that if such person executes a bond with sufficient sureties for his attendance before the court at a specified time and thereafter until otherwise directed by the court, the officer to whom the warrant is directed shall take such security and shall release such person from custody. My dear friend, this is the process of the warrant. If warrant officer, according to the direction given by the court, want to release such accused on bond, he can take a bond with sufficient securities, and after this, he can release the accused at once. But that person have to appear in the court according to the schedule is given to him. Now, my dear friends, I am taking third point. My dear friends, third point, proclamation of an absconder. According to section 82(1), if any court has reason to believe that any person against whom a warrant has been issued by it has absconded or is concealing himself so that such warrant cannot be executed, such court may publish a written proclamation requiring him to appear at a specified place and at a specified time, not less than 30 days from the date of publishing such proclamation. My dear friend, this is the third step of the court for enforcing such person to appear in the court. The proclamation shall be published or be affixed to the town and village in which such person resides. Second, it shall be affixed to the house in which such person and others his family members resides. Third, it shall be affixed to some conspicuous part of the court, and it is to be published in daily newspaper circulating in place where he resides or in the area where he is living. My dear friends, these are the conditions of proclamation. Where the proclamation is affixed, these are the 4 points where the proclamation is affixed or where the proclamation is published, so that the information is given to him by any person, or he can read himself by the proclamation. So this is the third point. Now I am taking fourth point. My dear friends, fourth point, attachment of property of person absconding. My dear friends, in third part, the proclamation process was, you have seen. Now in this fourth part, attachment of property of person absconding. After proclamation, the attachment of property. According to section 83(1), the court issuing a proclamation under section 82 may, for reasons to be recorded in writing at any time after the issue of proclamation, order the attachment of any property, movable or immovable or both, belonging to the proclaimed person, provided that where at the time of issue of the proclamation of the court is satisfied by the affidavit or otherwise that the person in relation to whom the proclamation is to be issued, A, is about to dispose of the whole or any part of the properties, B, is about to remove the whole or any part of the property from the local jurisdiction of the court. So in this condition, court may order the attachment or proclamation simultaneously with the issue of the proclamation. If the court feels or if the court thinks fit, the proclamation and attachment of the property, both the process may be issued or may go parallel. So this is the fourth condition of attachment of property of person absconding. Now I am taking fifth condition. My dear friends, fifth point, issue of warrant in lieu of or in addition to summons. This is the fifth point. According to section 87, a court may, in any case in which it is empowered by this court to issue a summons for the appearance of any person, issue after recording its reason in writing a warrant for his arrest. This is the first condition of the fifth point. Second, A. The first condition of this first point, A. If either before the issue of summons or after the issue of the same, but before the time fixed for the appearance, the court sees reason to believe that he has absconded or will not obey the summons. Or second point, B, if at such time he fails to appear and the summons is proved to have been duly served in time to admit of his appearing in accordance with, and no reasonable excuse is offered for such failure. This is the second condition. My dear friends, in fifth point, there are two conditions, A and B. And I think the language of the fifth point is very clear. Now I am taking sixth point. My dear friends, sixth point. Sixth point is power to take bond for appearance. This is the last point. According to section 83, when any person for whose appearance or arrest the presiding officer in any court is empowered to issue a summons or warrant is present in such court, such officer may require such person to execute a bond or without sureties, with or without sureties, both, for his appearance in such court or any other court to which the case may be transferred for trial. My dear friends, this is the sixth point. Power to take bond for appearance. According to section 83, when any person for whose appearance or arrest the presiding officer in any court is empowered to issue a summons or a warrant is present in such court, such officer may require such person to execute a bond with or without sureties for his appearance in such court or any other court to which the case may be transferred for trial. This is the language of the sixth point. I think, my dear friends, all these 6 points are, I think, are clear to all. So, these are the 6 conditions which a court may force for appearance of any persons in the court. Those accused who do not want to appear in the court, this is the remedy for them. So these are the 6 points which are applied by the court. So in the last, my dear friends, I want to make a request to you. Please subscribe the channel. I shall be very thankful to you. And the name of my channel is Maths by Dharamveer Singh Dabas. Again, please subscribe the channel